State versus Franklin Tucker, case 17 CF 841. I see prosecutors are here, but I don't see Mr. Tucker. Some word from the front door.
Hasn't even entered the building.
Okay. Has the state received any?
No, Judge, we have not received anything, Your Honor, based on multiple violations of your request to be a court on time. We're at the point where we're ready to ask for a case.
Yeah, I'm almost ready to issue it.
Our witness is here.
You want to tell him about state law? See if he wants to go a little later, Jim? That's what I'm saying. In other words, if we...
I take it. Well, I'll give it till 1:15, and if he arrives beforehand, then let me know. If not, then I'll go from there. So I see you've graced us with your appearance, Mr. Tucker. Where were you when the case was set for 1 o'clock?
I was again on my way here, Your Honor. You know, again, I'm not the best judge of the traffic and everything in Key West anymore. Apparently, I don't. I mean, I know I used to live here, but I also, I haven't been able to judge it. I was actually planning on being here early today, Your Honor.
Well, this is the last time, sir, because next time I'm going to issue a capias. You will be taken into custody, and we will then know where you are, because we have 14 people who are here on time, 2 more over there, 1 more over here, these people. For about the 6th time, we've sat here waiting for you, and it now is interfering with the orderly process of this trial. I have been more than indulgent with every step of the way in your plodding along and showing up late and your cavalier attitude. Be warned, next time I will grant the state's motion for capias, and we won't have this problem anymore. So there's nothing need to be said other than if you need to leave earlier, whatever you need to do, be on time.
Yes, sir. Yes, sir. That's all I want to say. Yes, sir.
So in any event, we're back, and Mr. Johnson is here.
Yes, Judge, I'll get it.
Thank you. Okay, Mr. Johnson. Well, it's afternoon, but good day in any event. So we're back here in trial in State versus Tucker, 17 CF 841. You're back on the witness stand. We're going to bring the jurors here in a moment. I just remind you, you were sworn to tell the truth yesterday, and that oath remains in effect today.
Yes, sir.
All right. Bring the jury in, please. One more? Okay, well, you can have a seat while we're waiting for our final juror to join us from the jury room. Okay, thank you. Everyone can be seated. Good afternoon, members of the jury. Good to see you all here today, albeit the beginning of the afternoon. As I told you yesterday, I did have a docket this morning, and we did accomplish what we needed to with those other cases, and so we're prepared to continue where we left off in State versus Franklin Tucker. The witness, Mr. Johnson, is here. He is still under oath, and we're going to continue with the cross-examination.
Thank you, Your Honor. May we approach the sidebar?
Yes?
Your Honor, I've talked to the state, and apparently the rest of the video that we were watching, they believe, I believe as well, it's mostly, mostly not more interviews. It's mostly, just Mr. Johnson sitting in the interview room, which I don't think would serve the jury very well. So we're going to go ahead and forego the last, I think, 10 minutes of the video.
Okay?
Okay, and in that case, I think we move on to, okay, let me grab this. Okay, Mr. Johnson, let's see if we can recap a little bit here. Now, we went over your interview with Captain Phelps, pretty great length. There's a couple other things I wanted to go over before we go ahead and excuse you. Now, you did say that you didn't go anywhere else prior to the treehouse that day and the beach. Is that it?
As far as I can recall.
17th, right?
As far as I can recall.
As far as you can recall. You don't recall going to CVS that night?
I do not.
And you said you would be surprised to learn if they had a picture of you outside of CVS. Is that correct?
This is what I said, correct?
So you don't recall going there, don't remember, don't know about the picture they took of you. Okay. Would surprise you to learn that that's actually just prior to the incident going down, and just prior to the crime.
Yes.
Now,
It surprised me, yes.
okay.
Mr. Johnson, could you keep your voice up, please?
Yes, sir. I apologize.
And let me go ahead. Apparently the mic didn't have a battery yesterday, so I want to make sure everybody hears me loud and clear today. Mr. Johnson, if, again, you saw a picture of you outside the CVS,
Objection, asked and answered.
I said, if he saw it,
Okay, let's hear the question, so go ahead.
okay, just prior to the crime taking place, what would that picture mean to you?
I don't know. I don't recall it. I don't recall going into the CVS.
Oh, you don't recall, what I asked is what would that picture mean to you? Did you say yesterday, I seem to remember you saying something like, get a lick or something like that, and you described to us what that meant. Hitting a lick, that's what it was.
Yes, I described that.
Okay, and what is hitting a lick again?
As far as the vernacular, as I understand it, it means to steal something, to take something, to come up from a broke position.
Okay, and is that criminal terminology?
It's a vernacular, slang vernacular.
Okay, but is typically used in criminal terminology.
I
Hitting a lick.
wouldn't know if that was what that was in reference to or not. No, that's just slang as I understand it.
Okay, but you understand it as a come up, right? To get something.
I believe I explained that, yes.
Okay, good. Just making sure we're clear. Now, do you understand the vernacular of casing a joint?
Yes.
Okay. Do you understand how a picture of you in CVS just prior to the crime could be considered casing a joint?
No.
I'm going to object to the
I'm going to sustain the objection. Sheer speculation.
Mr. Johnson, again, you also said that, what is it? Let's take a look here. Make sure I'm correct, because I may not be. Let's take a look. You said you emptied your truck, correct? As soon as you got up to Big Pine.
Yes.
This is when you discovered your Foot Locker.
I didn't discover my Foot Locker.
No, somebody put something into your Foot Locker. I'm sorry.
After I emptied my contents in my truck into the residence where I was residing, yes, this is when I discovered
Okay.
the backpack in my Foot Locker.
backpack in your Foot Locker, and you have no idea how it got there?
No, I don't.
And when was this Foot Locker out of your possession?
Several times.
Okay. Now, looking at the dates again, did you, you said that I helped you put your Foot Locker into your truck. Do you remember what date that was?
The date that I left.
Okay. So that would have been on the, what, 22nd? Oh, I'm sorry, no, it would have been on the 22nd. That would have been on, what? Yeah, that would have been on the 21st. Is that correct? Did that sound about right?
That sounds about correct, yes.
Okay, good. Because you said the day of the raid, right?
The day after, like the morning after, yes.
Morning after, so that would have been the 22nd. I'm just trying to keep our timeline here. Okay, so 22nd is when you moved, and supposedly I helped you move this Foot Locker. I seem to remember, let's go with my memory. Now, after the raid, I wasn't there, correct? I was at the police station.
I guess they took you into custody, yes.
Okay. Yeah, well, actually, you wouldn't have known where I was, that's true. Okay, so but I wasn't there, right?
No.
Okay.
Not when I got back, no.
Okay, and did I arrive sometime later?
Early that morning.
Early that morning. Do you remember about what time?
No.
Okay.
Before sunrise.
Before sunrise. Okay. And do you remember me saying anything to you after I got back?
No.
Don't remember anything. Did I have to wake you up to open the door?
No. I don't believe so. I don't remember.
Okay. You did have the only key, correct?
No, I didn't.
Well, you said Rory Wilson had a key.
Yes.
Okay, but, Rory was, to your knowledge, was Rory Wilson, man, was he actually still in jail at that point?
Yes.
Okay, so he didn't, again, obviously his key would probably be there with him, correct?
I don't know.
Or, again, would I have access to it most likely?
I don't know.
Okay. Actually, let me rephrase this. This is too much supposition.
I thought we covered this yesterday. This is all repeat testimony.
Well, I can't say with certainty, so we certainly
Thank you.
aren't going to cover what has already been asked and answered, but thus far I can't say with certainty that's the case.
Thank you. Let me go ahead and get this a little bit better. Because I want to do that. Let's go here. All right. Okay. Let's see what we got here as far as recaps. Okay. We've already covered the routes. We've already covered the knowledge. Okay. Again, could you do you happen to remember your phone number from that point in time?
I do not.
Okay. Again, did your lawyer again make you privy to any of the discovery concerning phone records?
No, not concerning phone records.
Okay. Now, in the video, we did see the detectives. If I remember right, did you? I would imagine you saw with us the detectives discussing your phone calls with Rory Wilson.
Yes, I remember that.
Okay. And they discussed how your phone calls were right around the time of the crime, correct?
I don't remember what time the phone calls were, no.
Okay. You don't remember when we watched the video what times they were talking about?
No.
Okay. Would it surprise you, again, I think you said your answer, again, I'm trying to clarify here because my memory may be messed up. I think you said that you told the detectives, did you tell the detectives something like, we were just talking, or, we're just talking or something like that?
Again, I don't remember the conversation.
Okay, not even after the refresher we had?
No.
Okay. I don't know if we want to go and repeat the video, but I don't know, we may have to. Now, let me converse with the state, if you wouldn't mind, for just a second.
Yeah.
Let's try this again. Mr. Johnson, do you remember watching the video yesterday?
Yes.
Okay. Do you remember the section where the detectives are talking to you about your phone calls with Rory Wilson?
Yes.
Okay. You don't remember the context of that conversation, or do you remember what you said in that video?
I don't remember what the phone calls were about between me and Rory Wilson. And I do remember in the video me saying the same thing.
Okay. You saying the same thing in there?
Yes.
Okay.
But I don't remember what the context of the video, of the phone calls were. I still to this day don't remember.
Okay. But you do remember the context of the video, right?
Yes, of course.
Okay. And you do remember the detectives asking you, or again, asking you in reference to the time frame of those video or of those phone calls.
Yes.
Okay. And how it is around the same time of the crime, before and after.
I remember the video, correct, yes.
Okay, so you remember them saying that?
Yes.
Okay, good. Okay, and now you said that you were in a hurry to get out of there, right? You wanted to get out of the warehouse, get away from myself and Mr. Wilson.
Yes, I said this.
Okay, and so you were in a hurry to get out of there.
My understanding of the word hurry is to move as quickly as I possibly can.
Well, then you agree on that. What would you consider as quickly as you possibly can, considering that, again, you learned that it was a homicide?
The time frame reference is between here and now. I really don't know how to answer that question for you.
Okay. Would you consider, again, you said you left the crime scene because you were scared and wanted to get away from the situation. I'm asking you, how quickly would you want to move out of the warehouse where you were still being subject to myself and Mr. Wilson, still being there?
As quickly as I could.
Okay. And as quickly as you could, would that mean a week, a month, a year?
Unfortunately, I'm not a fortune teller and I can't see the future, so I have no idea how long it was going to take me. I had no clue how long it would take me, and I had no specific time frame to reference to how long my hurry should take.
Okay.
I'm sorry.
Okay, would it surprise you to learn that the day after the crime, you had about 10 phone calls with Mr. Wilson?
No.
Okay, doesn't surprise you?
No, I don't remember these phone calls.
Okay, you don't remember those phone calls?
No.
Okay. Again, you moved out, was it the 22nd we agreed? Okay, so the 22nd, so the 17th to the 22nd, that, my count, that's what, 1, 2, 3, 4, 5. So 5 days, and you moved out, correct?
Correct.
Okay. And what were you doing in the meantime?
What people do to try to get out of where they're at.
Okay. What did you do to try and get out of where you were at?
Scheduled appointments with individuals that my girlfriend and I could acquire for me to get work, perhaps shelter,
Okay.
residence. These things take time.
I would understand that, and under normal circumstances, yes, that would probably be the case. What I'm asking you is, under the stressful circumstances that you were in, does 5 days seem like a long time?
Judge, I'm going to object to the question.
This has already been, we've already gone over this multiple
Okay.
times. I'm going to sustain
Okay.
the objection.
Again, how many conversations did you have with Rory Wilson after the crime?
I don't remember.
You don't remember? Do you remember any? You don't remember talking to him at all?
No.
Okay. And, let's see. You did. You said you didn't see Rory Wilson after that, though, correct?
Okay, what?
You didn't see Rory Wilson after the crime.
Yes, I did. I
Oh, I'm
walked with
sorry.
him back from Tom Thumb.
Walked back with him from Tom Thumb, spent the night with him there, correct?
Yes, the next few
Partying.
nights until the raid happened, yes.
A second, partying, correct?
For one night, yes.
Okay, and does that seem like the actions of somebody who's scared?
Do you understand what the actions of somebody who's scared are?
You have to just answer
I would like an
the,
answer.
not with a question.
I
so
don't know how to answer your question. Yes,
that's
no,
all you need
yes.
All you need
Yes.
to say, if you don't understand the question, you don't know how to answer it, just say that.
I'm just trying to, I'm trying to
Yeah,
understand.
we know, so let's just go on with between the two of you, question and answer.
I'm
That's what
trying-
we want.
I would like to understand, Mr. Johnson, why, if you were afraid enough that you took off and, left the crime scene the way you did, that you would sit there and party with these people when you got back.
Objection, Judge.
Yeah, I'm going to sustain the objection.
Okay. All right. So we established that, the very first, the crime afterwards.
Okay, I'll overrule that, but
Okay. Thank you. All right. Mr. Johnson, okay, after the partying of that night, again, did you see Mr. Wilson after that?
I saw him up until he was arrested at the raid.
Okay. You saw him up until,
Periodically, like, coming and going, yes, as well as you.
did you have any conversations with Mr. Wilson?
In passing, I don't remember specific conversations, no, but I'm sure that we spoke.
Okay. And you said that he held on to some of your belongings for you while you were in jail. Is that correct?
I said that he said that.
Okay. And did he, in fact, hold on to some of your belongings while you were in jail?
If you want to call it that, yes.
Okay. And I don't know. What would you call it, Mr. Johnson?
Theft?
Okay. So you're saying he stole from you while you were in jail?
That was my belief, yes.
Okay. And again, did you inform the police that he stole anything from you?
This is what I informed them that could have happened. I don't know if it was him or not.
Okay.
The investigators are the ones who were determining that. This
Okay.
was the only information that I could give them, is what I believed from what he told me and where my belongings were. This is what I told them.
And you told this to the police when you filed your report for robbery, not
That
after,
day.
not after the.
The day it happened, with the individuals, the officers that came when I called the police. That's who I told this to.
And you told them that Roy Wilson stole from you.
I told them I believed that the individual on the steps stole from me.
Did they question Roy Wilson?
I'm going to object to the relevance of this line of questioning.
I'll overrule the objection.
Thank you. Did they question Mr. Wilson at all?
No.
Okay, they didn't question. And did you in fact ever get any of your items back from that?
No.
Okay.
Not the ones I reported stolen, no.
Okay, but that was the guys they used when they brought you down to the station, correct?
Correct.
Okay, but you didn't get any items back?
No.
Okay. And you said, again, that you emptied your truck. Okay, when they went to search your truck, if you emptied it, why would there be items still left in there?
When my truck was searched by the police, this was months after I had been arrested. Months after I had been arrested. My truck had been towed from said residence and packed by whoever didn't want my stuff in their home anymore into my truck to have it towed to Mr. Martin Ochoa's residence. That's where the search was conducted, not at the time or point of my initial contact with police.
So to be clear, just to be clear here, your truck got towed from the residence you were at to Mr. Martin Ochoa's home. Is it a home or is it his business or something?
His home.
His home. Okay, so it got towed to his home with your belongings in it, correct?
Yes.
Okay. And you said this happened, the search happened months afterwards.
Yes.
Okay. Now, did anybody else, to your knowledge, have access to your truck at that time?
Everybody that possibly wasn't me. I was in jail.
Okay. Okay. When the tow truck actually took, did you have the keys, sir?
The keys were in my property. I did not have them, no.
You didn't have access to the keys?
No.
Okay, so that would mean the police had access to the keys or somebody else?
They were in my property.
Okay. And we did have the privilege of talking to former Detective Malone, who conducted the search on your truck. I think she described it as a lot. Does that sound correct to you?
A what?
A lot. You said it was Mr. Ochoa's home. She described it as a lot. Was it a lot?
I don't know. I've never been to his home.
Okay. And did you ever find out what happened to your truck after the police searched it?
It was repossessed by the bank.
It was repossessed by the bank. Okay.
Correct.
Okay, so you have no idea what happened to it after that?
Correct.
Okay, good. Now, again, amongst your belongings that they brought out in the search was, I believe, an extensive knife collection, if you want to call it that. Yeah.
Yes, it was.
Extensive. And if I seem to remember correctly, you like to take care of your knives. Is that correct?
I'm a blade collector, of course, yes.
You're a blade collector.
Yes.
Okay, and do you like to sharpen your knives and oil your knives and such things? And again, I'm not a very knowledgeable person in this thing, but I seem to remember that was something you liked. Is that correct?
Yes.
Okay. And would it surprise you to know that the residue from those things can be detected? The oils, the stone.
The stone.
And when you sharpen the blade.
Yes,
Okay.
I guess.
Okay. Well, again, now you said that the knife that has been used in this crime, you said that belonged to me, correct?
No, I did not.
I seem to remember you. Who did it belong to then?
I don't know.
Okay, you don't know.
No.
Okay. Okay. I'll save that one for redirect. And again, with the knife, you seem to have great detail when describing it in your interviews. How familiar were you with that knife?
Familiar enough to think that it was a dive knife.
To think that it was a dive knife. Did you know the color? Did you know the handle? Did you know the blade?
Yes.
Okay, all of those things.
Yes.
Okay, and again, how many times have you been in contact with that knife prior?
Once.
Once?
Yes.
Okay. And how long a period of time were you,
I don't recall.
Wait. Let him finish the question.
how long a period of time were you in contact with this knife?
I don't recall.
You don't recall? No. But enough to know the details of it, correct?
Sure. I'm interested in knives. I try to remember them.
Okay. So, but it doesn't take very long.
No.
A cursory glance, maybe?
It depends.
Okay. Okay. Let me go ahead and we're going to go ahead and, subject to the witness to recall, I'll go ahead and let we can end this and go for redirect, Your Honor.
Okay. Well, when you say subject to recall, you're talking about in your case? Is that what you're saying?
Yes, sir.
Mm-hmm. Well, I guess the cross-examination is concluded.
It's concluded.
So, State would like redirect examination?
Yes, sir. Yes. Judge, before I get started, I do want to move into evidence the video that the jury watched during the cross-examination. I have it marked here. Okay, I have it marked as P as in Papa. I seek to move this into evidence.
I take it there's no objection?
No, sir.
All right, admit as the State's next in order, number, what is it? 13. I thought we already had 13. I thought we were up to 15. All right, admit State's 15.
All right, now the state's 15 is in evidence. If you just put that in, please. I'll be referring to some portions of the jury I redirect, Judge. That's why I want to make sure it's queued up. All right, Travis. A couple things I want to clear up here.
Yes, sir.
You said way back when you came to Key West, you actually advertised Was it on Facebook?
Yes.
And you advertised for what?
For a position as a painter.
Okay, and did you receive calls through that advertisement?
I did.
All right. Can you say for sure whether you did or did not receive a call from this defendant during that early time in Key West?
I cannot say no.
Is it possible you received a call from him not knowing who he was or not knowing what your future with him would entail?
Possible.
Okay. So the first time you remember meeting him is when?
When I got out of jail.
And you were living at the warehouse?
Yes.
And when you first met him, where was he?
At the warehouse.
Was he with anyone at the time?
I was with Detroit Wilson, Rory Detroit Wilson.
And that's the other one that's involved in this plan this night of this
Correct.
robbery. Now, Travis, you agreed to get involved in this, I guess, this plan, and your expectation was to what? What did you expect to get out of it?
Gas money for my truck.
And at that point in time, are you familiar with the legal concept of the principal theory?
At this time, no.
Did you know that you could potentially be held liable for anything that happened inside of that treehouse, even though you were only the getaway driver?
No, sir, I did not.
Now, the plan, to be clear, was to go in there to commit a robbery. Is that right?
Correct.
And again, what was the goal in going into that treehouse that was discussed between you, this defendant, and Rory Wilson?
To get the money in the crack that the resident had.
And again, that lead came from somebody at the Burger King. Is that right?
Correct.
Now, you said several times that lead was brought back from Burger King by Rory Wilson, right?
Correct.
And then at one point, I think on one of the tapes, you said something about Tyrone. Is that right?
Correct.
Was that a misspeak on your part?
Yes, it was.
As you sit here today, do you remember who brought the lead back to the
Yes,
warehouse?
I did.
And who was that?
That was Rory Wilson.
All right. He brought the lead back, and who did he share that lead with?
Mainly with Mr. Tucker.
And
me.
And you.
Yes, I was in the room.
Okay. And at some point, you got involved in the plan to go over there.
Yes, I did.
Now, there seems to be a little confusion on the cross about how many trips over to the treehouse were made prior to the actual robbery. So let's be clear. You had testified that you guys went over there and did, I guess, for lack of a better phrase, a drive-by. Is that accurate?
Yes.
And after the drive-by, were there people or cars at the treehouse at the time?
Yes.
And you guys went back to the warehouse?
Yes.
And when you went back to the warehouse, what was the purpose in going back to the warehouse?
For clothing.
And about how many minutes later, if you can estimate, did you guys head back over to commit the actual lick?
I feel like about 5 to 15 minutes. I'm not 100% sure of the timeline.
Okay. Now, okay, good. I retrieved item number 7. It's in evidence from the clerk. Chris, let's go into the electric one. Or let's go into the other one first, the Cosme. David, if you can help me.
Which video is that?
All right, Chris, let's go to 1943. Travis, it's coming up here, 1943 and 22 seconds. Perfect. Okay, right there. Is that consistent with your truck pulling over to the treehouse?
Yes, sir.
All right. And is that consistent with what happened on the day, November 17th of 2017?
Yes, sir.
Now, on this is your initial approach. Is that accurate?
Yes, sir.
Did you guys stop or did you continue going after that initial approach?
I continued going
And again, if you can refresh the jury, why did you do that?
because there was somebody there.
All right.
Or is this is the first one? No, this was the initial drive-by.
Not the initial, right?
This is the one before I stopped and they got out.
Okay. So after leaving the warehouse, when they were dressed in black and with weapons, this is your first approach after you left the warehouse?
Yes, correct.
Now, if you look to the right of this boat, between these two boats, back in this area, we see your truck go all the way through. Is that correct?
Yes.
Now, there's some talk here. There's a glare there, right, on the front of this boat?
Yes, correct.
Do we know where that glare is coming from?
No, sir, we do not.
It's obviously not your headlights, right?
Obviously.
I mean, where's your truck at this point?
Not there.
Is there a glare coming from this window?
That's a light
A light?
on, yes, that's a street lamp at the CVS.
Okay. But the glare that we're seeing there, is it fair to say that's not coming from your truck?
Yes, this is fair to say.
Because your truck at this point is where?
Not there.
Okay, not there. Where is your truck? Tell me where your truck is right now.
Driving around the block.
All right, fair enough. Okay, Chris, if we can go to, actually, just let it play. Going to my time pen, it's gonna be 1945. Chris, if we can just advance 1945, that'll.
Your Honor, may I move up a little bit closer so I can see here?
Yes.
Thank you.
And Travis, I'm gonna again have you focus your attention to the left of that big boat that's in the middle of the frame.
Yes, sir.
Awesome. Do you recognize that?
Yes, sir.
What is it?
My truck.
Okay, now, a minute and a half, 2 minutes later, right?
Correct.
Minute and a half later?
Correct.
All right, would this be consistent with you reapproaching the treehouse after the first drive-by?
Correct. Yes.
Chris, if you just play for me? Now, focus your attention over here. Keep going. Pause. Can you tell for sure where your truck is at this point?
100% no.
Now, there's a couple different glares going on here, right?
Yes.
Chris, if you can back up for just 3 seconds. Okay, number 1945. Is that you there?
Yes, sir.
All right, what's what we just saw? Go ahead, Chris. Focus over here, Travis, if you would. We can see a flash from your headlights as it approaches. Is that accurate?
Yes, sir.
But do we know where the truck is stopped at this point?
No, sir.
Kind of hard to see in this video?
Yes, sir.
Now, we still see the light going on here, right?
Yes, sir.
Is that coming from your headlights?
Probably not, sir.
Okay. Headlight. Now, your testimony is that this defendant and Wilson got out of your truck, right?
Correct, sir.
Is that consistent with what we see there?
Yes, sir.
All right? And that's at what time now? 19:45 and 40 seconds. And Chris, would you take us to 1951, please? Travis, if you look over here, do you still see a light over here?
Yes, I still see a glare.
Where's your truck at this point?
It's still sitting right there.
Is it in, can you see this frame or not?
No, sir.
Now, we just saw somebody run up the hill, that's, we said before, that's what went, correct?
Correct.
Right there. And again, who do we see running there dressed in black?
That's Mr. Tucker.
The defendant.
Yes, correct.
And you didn't see Wilson leave?
No, sir, I did not.
All right, Chris, I'm done with this one. Let's go back to the clerk. All right, Chris, that's one, all right, perfect. All right, I'm going to bring your attention to some times here in a minute. Now, all right, Travis, so we've covered the videos from the night of the event. I want to go to what was going on with you after they brought you down to the station under the guise of looking for your items from your truck.
Yes, sir.
Now, you got to the station that night, right?
Yes, sir.
Initially, when they switched the script on you and they started asking you questions about what happened at the Treehouse, were you surprised by that?
Yes, sir, I was.
Did it catch you off guard?
Yes, sir, it did.
And initially, during your conversation with them, did you come clean right away and give them
No, sir, I didn't.
own up to what you had done?
No, sir, I didn't.
What were you doing?
I was backpedaling. I was scared. I was processing in my mind what avenue I wanted to take.
And so, as they asked you questions, were you being 100% truthful with their answers?
No, sir, I wasn't.
Were you trying to mislead them or diffuse them?
A little bit, yes.
Were you worried about minimizing your involvement in this crime?
Yes, sir, I was.
Again, at this point, were you familiar with the principal theory?
No, sir, I wasn't.
Were you familiar with the idea that you could be held accountable for everything that happened, even though you were in the truck that night?
No, sir, I was not.
As they questioned you, did they start to confront you with more and more evidence that they had in the case?
Yes, sir, they did.
Now, you specifically testified that Phelps put it together, right?
Yes.
She's the detective or the lead that was in there?
She was the captain, yes.
The captain, okay. And you said on, I believe it was on direct and on cross yesterday, she nailed it 100%.
Very smart detective, yes.
When she went through the events with you, were you surprised at how close she was to the truth?
Yes, sir, I was.
And as she talked to you, and we saw it in the video yesterday, did she present you with her theory of what happened?
She did.
Okay. Now, let's go, Chris, if we could, to 2019, please. It's at 2019. I'm not sure which one it's going to come up on. Maybe that one. Okay, no, we got to go to 20 and hour 2019 minutes.
I mean, I'm live full time. Without one key. And key there, yeah.
And do you want some water?
Might be, we've been able to verify. Good guy. Stop up in his head. Okay, we'll get out. You just, whatever. It's completely okay. I don't think that it's going to just look like a, with all that BBC, I don't know that. Where are you from? Yeah. Once you get to my city truck, it'll be, but, raise your mind. Just the night by itself. Not yet. We can still look at the last night. Like service, you have a shirt. How would
Okay, Chris, go ahead and stop.
20s, 10s, 5s, what? Some. And 5s. Okay. The money's gone.
And pause, Chris.
When you saw Tyrone.
Now, we're at the point of the interview where you were talking more clearly with Captain Phelps. Is that fair to say?
Yes.
Are we at the point where you have decided time to come clean?
Yes.
What brought you to that decision, Travis?
Actualization of the fact that somebody was dead and I was responsible, and that, that I wanted to make sure that this was resolved.
Now, at that point, you decided time to own up to it?
Yes, sir.
And is that what we saw in the video yesterday where you got very upset? I think you had a moment where you really got overwhelmed?
Yes.
Why is that?
Actuality, reality slapping me in the face.
The reality is that you were involved in an event that turned into a homicide.
Correct.
Scary stuff, right?
Yes, sir.
Now, you're talking to Captain Phelps, and she's asking you about the knife, right?
Yes.
Did she tell you what the knife looked like?
No.
Did you tell her what the knife looked like?
I did.
I mean, they knew a knife was involved, right?
Yes.
The guy had been stabbed to death, right?
Yes.
So when she asked you about the knife, did you describe the knife?
I did.
And how did you describe it?
I described it the way it looked, the way it is.
Red, black and red.
Black and red with a serrated edge. Yeah, black and red with a serrated edge and a smooth edge on one side and a silver pommel on the bottom.
Had you seen that knife before?
Yes.
How many times had you seen it?
Once or twice.
Where did you see it on the night of the Treehouse stabbing?
And I saw it in the house, and then I saw it in Tucker's hands.
Tucker's hands.
Yes.
You guys sit right there.
Yes.
It's in his hands when he came out of the house.
Yes.
Dressed in black?
Yes.
You're telling Captain Phelps. Now, when Captain Phelps was asking you about details about the knife, did she show you the knife?
No.
All right. You told her what was the handle.
Black and red.
All right. What about the blade? Did you tell her about the blade?
Yes, I did.
What'd you say?
Serrated on one side and sharp on the other. Smooth on the other.
Serrated on one side, sharp on the other. Throughout your interview with Captain Phelps, what did she tell you she wanted from you?
The truth.
The what?
The truth.
The truth, right?
Yes.
She say it more than once?
Yes.
Matter of fact, at one point, doesn't she say to you, tell us what happened, and your response to her is what? You just said it,
Yes.
right?
Yes.
When you said you just said it, what were you meaning when you said that?
I was meaning that she knew the truth. She had, through her theory, for lack of better words, nailed it. And
And
she
what was
just
her,
said it.
did you recall what her response was when you said you just said it?
She said she needed to hear it in my words.
She wanted to hear it in your words, right?
Yes.
You tell her what happened. And then you went and you started telling her exactly what happened. Is that fair?
Yes.
At 2020, Chris? Yes, please. And I'm gonna let it play for a couple minutes, because then there's a couple things within the next 2 minutes I wanna talk about, okay?
Do you trust, do you know who killed the guy? Did they ever tell you who killed him? If you had to guess, one person that was there, who would you think would have done that?
Pause, Chris. She asked you if you knew who stabbed the guy, right?
Yes.
And she asked you if you had to guess, which one would you say?
Yes.
And what was your answer?
I didn't know well enough to develop a guess. I didn't know either one of them well enough to know who would done it.
Did she give you the name of Tyrone Tucker, or did you offer the name?
I offered the name because she said that I knew who did it, and I think I offered it in the form of a question.
So you offered the name of Tyrone Tucker, not Penny Phelps.
Correct.
You're the one that brought that name into this narrative. Is that fair to say?
Yes, sir.
Not Penny Phelps.
Correct.
So when the defendant says this was her narrative that you simply endorsed, that's not accurate, is it?
No, sir, it's not.
Go ahead, Chris, play. Chris, why is the video not?
Did you see Kyle put clothes on and clothes that like this?
Okay, the video's not buffering, I'm told. It's the same as the audio, but the audio is what's important to me at this point. The jury's going to be able to look at this. It's in evidence. So let's just go with the audio. Chris,
Your
go
Honor,
to.
can we sidebar for a second?
Yes?
Chris, if you go ahead and hit play then.
Did you ever see Maury taking a post that he wanted for them? Like in a bag, trying to get to the women? They just started to get rid of it first. Okay. And so it's $250. So like $250. That's pretty messed up, guys. Pretty messed up.
Chris, can you turn it up at all? Okay.
Before the robbery happened, what did you think was going to happen if you told them, no, we're not doing it? What did you think was going to happen?
Next piece.
So when you were saying you made a decision last year, you were afraid. More than, did you know what was going to happen? Okay.
Go on until I can get an opportunity to get out there safely.
You're a safe place now.
Yeah, but how safe for me is just working and where my stuff is, and earning my living and going on and on. I don't have to.
Excuse me, you building up to a question here, or just?
Yes, Judge.
Okay.
All right, Chris, go ahead and pause. I was hoping to get to the part, Travis, but let's just talk about it. At one point, you offered to draw a map. Is that accurate?
Yes.
And what was that map? What were you requested to draw? Or what did you request to draw when you wanted to draw a map?
The route.
And did Captain Phelps tell you what route you took?
No.
Did you tell her what route you took?
Yes.
Matter of fact, at some point, she says something on the map, and you correct her, don't you?
Yes.
She's pointing in the wrong direction, and you actually corrected her as to which direction your truck was going.
Yes, sir. I believe it was.
All right? At that point, is this your narrative or her narrative?
Mine.
Yours, right?
Yes.
You gave a detailed description about the planning of the robbery, correct?
Yes.
Did they know about the details in the plan?
No, sir.
Where'd those details come from?
They came from me.
What about the details in Rory Wilson's mask? Is that something they provided to you?
No, sir.
Where'd that information come from?
They came from me.
What about the gaiter that this defendant was wearing? Did she provide you with that information?
No.
I'm sorry, what's the objection?
If there's been established those wearing anything.
Well, I disagree. That might be a point of contention, but it's a legally cognizable question, so I'll overrule the objection.
Let me ask it again, Travis. So the gaiter that this defendant was wearing, did Phelps give you details on that?
No, sir.
Where'd that information come from?
It came from me.
Now, describe the defendant. He looked different back then, 6 years ago. Is that accurate?
Yes.
Tell the jury about how he looked. Did he have a bigger goatee, smaller goatee?
He had a goatee about this long. Straight down.
Long.
Long.
All right. Did he have a full set of teeth?
No.
And the gaiter that he pulled up, does that cover his goatee?
Yes. Yes. I apologize.
The knife you gave the details on, is that fair to say?
Yes.
Now, the money that you got, you said it smelled like perfume.
Yes.
Is that something that they told you, or is that something you gave to them?
Something I gave to them.
The defendant brought up the scenario about April Walker. Again, who was April Walker?
Rory Wilson's girlfriend.
Rory Wilson's girlfriend. Was she living at the warehouse as well?
Yes.
The defendant asked you about these threats and the timing of these threats. Do you remember on cross?
Yes.
When you left for Big Pine, was April still in that warehouse?
Yes.
And you said to the defendant when he asked you, she didn't appear to be nervous or scared, right?
No, sir.
I believe that's what you testified to on cross.
Yes.
Now, you were up in Big Pine for at least a day, then they brought you down to the station, right?
Yes.
In that tape, when we see Captain Phelps come into the room and tell you that April Walker's nervous and scared, is that before or after you left the warehouse that morning?
After.
After, right?
Correct.
So when you left the warehouse, had April Walker received those threats?
Not as far as I know, no.
When Captain Phelps came in the room, what did she say?
She said that April had received threats.
Had just received threats.
Just.
Defendant also asked you about whether you saw blood on him or on Wilson that night, right?
Correct.
What color clothing were they wearing?
Dark. Black.
Is it easy to see blood on dark black clothing?
No, sir, it's not.
Were you looking for blood on them that night?
No, sir, I wasn't.
Had you suspected that somebody had been stabbed to death inside the treehouse?
No, sir, I hadn't.
So when you walked with Wilson back from that CVS, I'm sorry, I apologize, when you walked with Wilson back from Tom Thumb, were you looking at him, his body, to see if there was blood on it?
No, sir.
When you and this defendant were in the warehouse right afterwards, and this defendant was mad at you for having left him, were you looking at his body for blood?
No, sir, I was not.
Again, what color clothing was this defendant wearing?
Black.
After you left, that place in Big Pine, you said your truck was empty when you left, right?
Correct.
And you had unpacked the stuff into the house, right?
Correct.
Then the police came and looked at your truck, right?
Correct.
And then they invited you to come down to the station and look at this other stuff they had, right?
Correct.
Did you ever see your truck again after that morning or that day?
No, sir.
So when you left Big Pine, you never saw that truck again?
No, sir, I didn't.
When you left Big Pine, was the truck empty?
Absolutely empty.
So how did you find out that somebody had taken all your stuff out of the house and put it back in the truck?
When I received the search warrant affidavit.
Okay. Were you surprised to find that all that stuff was in your truck, or did you figure that's what was going to happen with your stuff?
I figured it was, I really didn't know, but yes, I was surprised to know that it all had been piled into the bed of my truck.
Now, you are a knife collector, right?
I am.
You had a pretty extensive set of knives. Is that fair to say?
Yes.
And were those knives back in that truck again after they cleaned out the house that you were staying at?
Yes.
Or that you were going to stay at, right?
Yes. Yes, the knives were in my possession when I went to that house, correct?
Okay. Now, when you finally decided to own up to your involvement, that's when you, I guess, came clean with the detectives, right?
Yes, sir.
Did you do that before or after they showed you the videos from the electric company and from the Cosme Marina?
Before.
So those videos that this jury has seen, you were not shown those until after you gave them your statement. Is that accurate?
Correct.
It's been 6 years. Can you still, in your memory, clearly see this defendant running from the court, the treehouse that day?
I can.
The defendant asked you today, you wanted to get out of there quick, right? You were scared, you wanted nothing to do with this, right?
Correct.
But you still wanted to get high, right?
Of course, that's the insanity of addiction.
So you weren't about to leave until all the drugs had been smoked, at the very least, right?
Correct.
Let's talk about these deals. You came in and you gave statements, right?
Yes.
And we just went through the one that you gave to the detectives back in 2017. Is that fair to say?
Correct.
We played that pretty much in its entirety yesterday, right?
Correct.
Now, in April of 2022, you were approached again about potentially potentially entering into cooperation with the state.
Correct.
And before we talked about any deal, did you in fact give another sworn statement?
I did.
And that was prior to any deal being made. Is that accurate?
Correct.
Judge, at this time, the state is going to move into evidence what has been marked as P as in Papa.
Objection.
Well,
It's already been marked.
wait. P has been admitted into evidence.
Oh, okay, then it's O.
So then we need to,
Okay.
Your Honor, can we sidebar again?
Well, in a minute. Right now, I'm going to set the stage, or let the state set the stage for whatever they're doing, and then we'll...
Okay. There you go.
so where's the, you want this one in evidence now? Is
Yes,
that an objection or?
Well, do we have an exhibit that's marked?
Yes, Judge,
What
it's
is
marked
the-
O as in Oscar,
Okay, and what are you doing with it?
seeking to move it into evidence.
Okay, is there an objection?
Yes, sir.
Okay, so now we'll approach the bench. This won't accommodate. Okay, the jurors are gone, so first of all, I don't know what O is. I mean, you ask the witness if he remembers back in, I think, April 2022, making another statement, and moved O into evidence.
Yes, sir. So, Judge, I'll let me explain. In April of 22, when we approached the defendant about potentially doing a deal with him, we said before we talk about anything, we want a sworn statement. And he gave us a sworn statement. Normally, that statement would not be admissible. It would be hearsay. However, under Rule 90.801...
No, wait a minute. So O is some...
O is that proffer that he gave, an audio of the proffer or the sworn statement that he gave to my office.
So you're moving it into evidence on Mr. Tucker's objecting, so let's hear what the state's basis of admissibility is.
90.801, subsection 2, subsection B. A statement is not hearsay if the declarant, Mr. Travis, testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. This defendant has been attacking this witness now for a day and a half about, you'd do anything to get out, wouldn't you? You'd say anything. You even said in the video, I'll do anything you want. He has made allegations of a fabrication on this defendant in order to get a deal. He's made allegations of improper influence of Penny Phelps. And he's made allegations of the motive to do it, meaning this defendant did not want to go to prison for life. So basically, he's here saying anything he has to say in order to avoid that. That's specifically what this rule is meant to address. So normally, a prior consistent statement would not be admissible, but now that that has been established, it is my position that statement should be admissible as a prior consistent statement offered to, I guess, to rebut allegations of improper influence, motive, or recent fabrication.
And the defense's position is?
The defense's position is that, again, as far as his motives, as far as the deal he cut, yeah, that one is self-explanatory. I didn't have to point that out. As far as Ms. Phelps, is she going to be addressed in that statement? The statement that you're trying to enter into evidence on cross? I mean, not a cross, I'm sorry, on redirect. You're trying to introduce new evidence into redirect, and does that actually does it say anything about Penny Phelps?
I don't know.
Because, I mean, that's what he's using to establish this law here. He's trying to say that, you know, because we question Mrs. Phelps's motives, that would establish this law.
It's not a question of Phelps's motives, it's a question of this defendant, or this witness's motives. He has been alleged to have fabricated this story in order to get a deal. He is alleged to have been improperly influenced in order to provide this story. This is specifically what this rule is designed for. It is specifically designed for a witness such as this who has been attacked by his motive for testifying, the content of his testimony being improperly influenced, and that it was fabricated to get a deal.
But does it allow you to enter new evidence on redirect?
Well,
Well, Judge, I'm not teaching law to the defendant, so.
We're having a legal argument. This is exactly what should I? when this whole business about the defendant wanting to play the interview, interrogation, whatever you want to call it, of Johnson with Penny Phelps, this is what I don't want to say warned about, but acknowledged that the door may be opened.
Yes, sir, that is correct.
Understand, Your Honor.
Excuse me?
I said I understand, Your Honor.
Okay, so now the question is this within that rule? So what's the rule?
Judge, it's 90.801, parentheses 2, subsection B.
What subsection?
I'm sorry, Judge, subsection 2B.
Table 4.
90.801.
Okay. The statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is, subsection B, consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. I don't think this is recent fabrication, because recent fabrication would mean that somehow or other he's being alleged to have, in the very, close to his testimony, fabricated, and then the advocate for that witness says, no, here's something that he said months ago that shows that this isn't recent fabrication. So it seems to me it's improper influence, that the Penny Phelps interview was played by the defendant to say that Penny Phelps fed you this narrative, to use the term that's been employed here, and you basically said, yeah, that's it, and it was her idea, not his idea. So, just the timing that I'm wondering about here. So the timing was the Phelps interview was in, when did we say? In
2017, Judge.
The testimony here is in 2024, and the statement that you want to admit is in 2022. So could you just explain the argument again, Mr. Mansfield?
Right, Judge. So now that he has attacked the veracity of his statement as having been coerced by Penny Phelps, well, he gave another statement almost 5 years later, and it's consistent with the testimony he gave this jury on direct examination. So again, if it was the Penny Phelps story, well, 5 years later, he gave a consistent version of those facts, identical to what he testified to this jury today. I'm sorry, during this trial.
Okay, and so anything further from the defense?
Well, I believe you already admitted there's inconsistencies between the interview he gave with Penny Phelps and what he's given today. Why would that be any different in that statement?
inconsistencies. I believe the whole implication that the defense is wanting to say is, it's basically the whole thing is a lie, that it's Penny Phelps' version of events that Johnson has just adopted as his own in so many words, and he's fine-tuned it a bit,
Yes.
but
Your Honor,
Yes,
if
sir.
I may, you know, the statements that he made, you know, again, Penny Phelps' time, yes, we do believe that they were fed to him. However, he's had 6 years now to fine-tune those statements. So, you know, again, you know, even all the, yes, he was there, he can draw a map, yes, he's there, he could do all that, he could do everything that the state's saying, that's true, because he was there, that's very simple. And yes, because he was there, he can give all that information and probably keep it accurate. The part that's problem is that Penny Phelps gives him the one key that he needed to get that deal. I'm the getaway driver.
Judge, he keeps arguing the very nature of why he keeps arguing that Penny Phelps unduly influenced this defendant. And the rule allows for me to play a prior consistent statement that corroborates his version because the defendant has attacked it as being unduly influenced.
Your Honor, if I may, one other thing.
yes, sir.
Okay, this prior inconsistent statement, I mean, that would make sense if he had actually given that consistent statement prior to Penny Phelps. I'm sorry, prior consistent statement prior to Penny Phelps. Then it would make sense.
Judge Jones?
Yes.
In an abundance of caution, because I don't want to create an appellate issue, I'm not going to move it in. I'm not going to seek to move it in.
I think that's a wise choice. It's because one way or the other, it's a close call. I mean, one way or the other, it's a close call.
I truly believe this is the kind of trial that you get one shot at, so I don't want to create that issue.
Fine. May I ask, do you have a witness standing by?
Yes, sir, we do. Two of them.
I'd like to do recross, Your Honor.
Well, I don't think that's going to happen, Mr. Tucker. You've had more than ample opportunity to cross-examine about everything multiple times, so we're not going to be having any recross, sir.
Okay.
That's not the norm to begin with. I made an exception, but anyway, I won't repeat myself.
Judge, I just have a brief follow-up, and I'm done with this witness, and we'll move on to, I don't even know what time it is.
All right, bring in the jury, please.
Mr. Mansfield, who did you tell me to call? Mr. Mansfield,
I'm sorry?
was it the Emmy or the Angela?
Whoever's sitting out there, one of the
One of the two.
Okay, the clerk is concerned if there's some exhibit that's in the machine that she doesn't have. She's very mindful of keeping track of everything, which is definitely desirable. Thank you. Please be seated, everyone. Thank you for your patience. We've handled our business and back to the redirect of the defendant.
Thank you,
the
Judge.
witness, excuse me.
I'm sorry, sir. So picking back up, Mr. Johnson, so just to confirm, when you were approached in April of 22 about working with the state, you gave another sworn statement,
Correct.
and then you testified to the jury today.
Correct.
Were you consistent with that statement?
Yes.
Just one second, Judge. Judge, at this time, I have no further questions for this witness. Thank you, sir.
1 second. We're going to need to approach the bench here. Testimony now. You are subject to recall. So my suggestion is that you maintain some contact with the state to get further details.
Understood, Judge.
Any other instructions anybody wants at this point?
No, sir. I just would, since he's still under potential recall, no talking about the case to anybody outside the courtroom.
Correct. Okay, take care. All right, so the state's next witness.
Yes, sir. We're going to call Dr. Michael Steckbauer.
Okay, I didn't know, I forgot. So you. Yeah.
Sir, if you please step forward to the gate right there. Approach the deputy who's positioned right in front of the witness stand. You stop about right there, turn, face this lady, raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you. Have a seat on the witness stand, please. Good afternoon, sir.
Afternoon. Judge, may I proceed?
Yes.
Dr. Steckbauer, you all set up? Okay.
I am.
All right, good. Good afternoon, sir.
Good afternoon.
Dr. Steckbauer, could you state your name for the jury?
Absolutely. I am Dr. Michael Robert Steckbauer.
And how are you employed?
I am the current District 16 medical examiner.
Did I mispronounce your name just now? Okay, good. Dr. Steckbauer, you are employed as our medical examiner?
I am.
And how long have you been doing that work down here in Monroe County?
About 6.5 years.
Okay. This is the part where I ask you to take the jury back a little bit about the progression of your career to get you to where you're at today.
Yes.
Yes, sir.
So that long odyssey started many years back. I went to undergraduate. Well, actually, that's not really true. Initially, out of high school, I went into the military. Did an active duty stint in the Army for 6 years as a veterinary technician of all things. Thought I wanted to go to veterinary school. Clearly wanted to go to medical school. So then I went off to the University of Nevada, Las Vegas, and finished my bachelor's. I got a bachelor's in science with a minor in chemistry. Biology is the major, and minor was chemistry. I then went on to the University of Nevada School of Medicine to medical school, and I completed my medical degree. After that, I went off to my residency, which was in pathology, anatomic and clinical pathology. After completing that program at Ball Memorial Hospital in Muncie, Indiana, I did take what is called my anatomic pathology board. This is essentially a test that one can take. You don't have to take it to practice, but if you take it, it shows that you have achieved a certain level of knowledge. So I did achieve board certification in anatomic pathology. I then attended my forensic pathology fellowship at the Miami-Dade Medical Examiner's Office. Upon completing that fellowship, I did also take my forensic boards and achieved board certification in forensic pathology. That entire time I was in the Army National Guard as well. I was a combat medic initially, and then later, upon completion of medical school, I went to the Army's Flight Surgeons course and have been practicing with the Army National Guard as a flight surgeon since. When I graduated that fellowship, I went off to Duval County, Jacksonville, as an associate medical examiner. I was there for about 2 years, and during which time I was deployed to Kosovo with the Army National Guard. I then went down to Broward County as an associate medical examiner in 2013. Was there for a number of years, ultimately becoming their director of medical education at one point, later becoming their deputy chief, and at the end of that being deployed to Kuwait and Iraq with the Army National Guard. After that, I then came down here and have been in this position since. During this time here, I also have a private practice. I do the forensic autopsies for the Royal Police in the Turks and Caicos Islands, almost all of their cases. I do the hardcore forensic cases for the Royal Police in Bermuda, as well as in the Cayman Islands, and do private autopsies. I think that covers everything.
Okay. So you mentioned the phrase forensic pathologist, right?
Yes, sir.
All right, let's tell the jury, what are the duties of a forensic pathologist?
Forensic pathology differs from general autopsy medicine, autopsy pathology, in that it specifically centers on medical legal death investigation. And really kind of to just be generally broad with that, it means we do autopsies that are legally mandated on things that would meet the classifications of manners of death of homicide, suicide, accident, so strange we just don't know what it is, undetermined. Now we do plenty of natural deaths as well in that work, but they're simply because there's no regular doctor to sign, or they don't know exactly what's going on, and so they're kind of questionable and they come to us. And so we do the background investigation into those cases. They come into the office. We do the autopsies on them, interpretation, follow-up interpretation of toxicology test results, and microscopic examination. Of course, we testify on those cases, such as I'm doing here today. We do education for law enforcement and fire, as well as a number of other people. We occasionally have medical students, residents, paramedic students rotating through the office. We do education with them. Occasionally we do outreach to different organizations, do training as well.
Doctor, you talked about autopsies. About how many autopsies have you performed in your career?
Well, I quit counting a number of years back. I'm probably roughly about 5,000 at the current moment.
And how many down here in Monroe County? Can you even estimate, or is that a rough
Well,
one to get
we
to?
do about 150 a year here in this county, 6.5 years, so you can do the math on that. It's roughly about 900. But of course, as I said, during that time, I have continued to do the cases for the Royal Police in those different island nations. You add those on top of it, it's probably somewhere around roundabouts another 100 cases, including my private autopsies per year. And then I did, in fact, help out the chief medical examiner in Palm Beach for a number of years. I'm not really sure how many I did total for her, but if we say somewhere between an estimate of 250 to 300 per year.
Wow. Now, are you a member of any specific groups or specialized groups?
Yeah, most pathologists, and specifically forensic pathologists in the United States, will be members of the National Association of Medical Examiners. It's really our only major group. We do have another group, but they're very minor compared to NAME for membership. Almost all forensic pathologists in the state are members of NAME. And then I am a fellow of the American Society of Clinical Pathology as well.
Have you ever been published?
I have.
And when I say published, what are we talking about?
Most of the time when you're talking about published, you're talking about either case reviews or full clinical research.
And you have been published before?
Yes, absolutely.
Do you receive continuing education in your field, or is it you've already known it, so that's it?
No, there are no current residencies under the guidance of the American College of Graduate Medical Education that are allowed to not do continuing medical education. You have to. So I do continuing medical education. I do that both for my board certification as well as for my medical licensure. The state licensure board here in Florida requires 30 to 40 credits of CME per year. Some certain classes mandated, others you can do it in whatever area of medicine you'd like. And then the American Board of Pathology requires 70 credits themselves.
And do you have to do that to maintain your accreditation or your certificate to practice?
My certification.
Certification.
Now, there is, I guess, one other caveat to that. I was unluckily one of the last people in my year group period that still had to take a high stakes test at 10 years to renew my board certification. Thankfully, they got rid of that and they changed it in pattern, but I did actually about a year, I think that was a year and a half ago, I took a large exam, 10-year exam within my field to show, in fact, that I did still know what I knew and that I had kept up on it.
Now, are you board certified by the American Board of Pathology?
Yes, that is correct.
Is that above and beyond your regular certification, or is that the one we're talking about?
That is the one we're talking about.
All right, fair enough. Now, let's talk, you already explained to the jury an autopsy. You said an autopsy can determine cause and manner of death. Is that right?
Yes, that is correct.
So let's talk about the difference. When you say cause of death, what are you referring to?
The cause of death is that thing that led to the physiologic derangement in the body that was no longer compatible with life. The manner of death is a category that the cause of death fall within. I like to use the example of things like a firearm death. You can have a firearm death that is in fact homicidal. Somebody pulled the trigger and caused that person's death. You can have a firearm death that is suicidal. Somebody pulled the trigger themselves. You can have a firearm death, although they're not common, you can have a firearm death that is going to be accidental. The firing pin or something is malfunctioning and the weapon gets jostled, goes off, and the projectile strikes somebody. In that case, that's an accidental death.
Now, during the autopsy, you do something called an external examination and an internal examination. Is that fair?
That is correct.
Let's talk about the differences. First, external examination. What, if anything, are you looking for when you conduct that?
An external examination is exactly what it sounds like. It examines the external surface of the body. Now, I do tell everyone, especially when I have police from the Academy for the initial training, I say that the autopsy begins with the scene investigation. Whether that's a scene investigation that I directly perform or a scene investigation that the law enforcement officers have performed and relayed to me. You know, you can have a person who dies, and without that information, you're kind of flying blind. You have a 30-year-old, you know, who's dead in their bed. That could be potential drug overdose, could be suicidal, homicidal, and that investigation that they're performing is helping you to kind of move along the pathway of what may have caused it, and what sort of ancillary testing you're going to do. So then we get the body into the morgue, we do the intake, which is weighing the body, doing some photographs, and we examine the outside of the body. The general hair, state of the hair, color of the hair, length of the hair, if there's any findings in any of these things. The eyes, the general color of the eyes, if there's any findings in the eyes that would help to indicate to you what the cause of death was. Is there some yellowing? They could have hepatitis, things like this. The mouth, are there any findings in the mouth? 30-year-old who comes to you and has no other findings, and the teeth are in very bad repair, you're immediately going to be concerned about things like methamphetamine addiction. So the teeth can actually steer you in certain directions as well. You can find little linear lacerations that indicate a person was punched and the lips pressed against the teeth. You're then going to look at the outside of the body. Any marks, scars, identifying features, any tattoos, any injuries. Look at the genitalia. Are they normal? Are there any findings in the genitalia? And that roughly covers the external exam. Once you've finished the external exam and you've taken photography and documented it, you're going to move on to the internal examination of the body. Internal examination is exactly what it sounds like. You are going to open up the thoracic cavity and the abdomen via what is called a Y incision. The tissues will be reflected back. We document all of this in place. If photographs need to be taken, we do take them of any pertinent findings. We examine the organs in situ, inside the body as they present themselves, and then we remove them. We weigh them and we dissect them further. We take toxicology specimens as we go. If available, we try to get vitreous fluid from the eyes. We try to get peripheral blood, meaning blood that is away from the heart, towards the common iliac vessels. We gather urine if it's available. We gather bile from the gallbladder because certain substances are in fact concentrated in bile. Once we've done all of that, we then reflect the scalp, open the calvarium, of course examine the brain in place, take it out, weigh it, dissect it as well. We do keep small sections of, representative sections of all of these organs and any specific pertinent findings as we go. And again, like I said, we take photographs as we move along this process if they are needed.
Now, Dr. Stegmaier, let's take you back to November of 2017. Were you conducting autopsies in Monroe County at that time?
I was.
All right. And were you asked to perform an autopsy on someone who came identified to you as Matthew Bonnett?
I was, and I did.
All right. And did you go to the scene on this particular death?
No, I did not.
Okay, sometimes you do go to the scene, right?
Absolutely.
All right, this one you didn't.
No, generally if the body has been transported from the scene, of course, I'm a forensic pathologist, not a crime scene investigator. My expertise is in that body, and so generally if the body has been transported to the hospital or otherwise, we do not attend the scene, and that was the case in this situation.
Okay. Now, the identification of the body was Matthew Bonnett, is that right?
That is correct.
And you were asked to conduct an autopsy on Mr. Bonnett?
I was.
And do you recall when you conducted that autopsy?
Yes, the autopsy was conducted on the 21st of November at 10 a.m.
Is that at your office here in Monroe County?
Yes.
And were you alone or were you with someone when you conducted the autopsy?
Generally speaking, we almost always have a technician, and I would have had a technician on this case. I do believe at the time of this autopsy, Dr. Prasanna was present. There were a number of law enforcement officers who were present as well.
And okay, so you were asked to do the autopsy and you performed it, you said on the 21st, right?
That is correct.
Okay, so let's take the jury through the autopsy. First of all, can you describe Mr. Bonnett in general?
Absolutely. As per the report, the body is that of a 69-inch, 173-pound adult white male who appears consistent with the reported age of 59 years. The body was well preserved. It was cold. Rigor mortis was present. Livor mortis was present. It was posterior red, purple, and fixed. His hair was of medium length and white in color. The eyes were brown. The surrounding sclera were not icteric. The conjunctiva were not congested and did not have any petechiae. His nasal bridge was midline. The oral mucosa and frenula were intact, means he didn't have any defects within the mouth. The teeth are natural and in relatively good condition. and the external canals were free of blood. His neck was generally straight. His chest and back were symmetric outside of the injuries and medical intervention that were present. His abdomen was flat. His external genitalia were those of a normal circumcised adult male. The testes were palpable in the scrotum. His external anus was unremarkable. His arms and legs were normally developed. He did, in fact, arrive to my office with bags covering the hands. That is normal to do in cases in which it is believed that an altercation has occurred. It allows us to better process the hands and potentially take things like fingernail clippings, because DNA can be present underneath the fingernails from the person that they may have gotten in an altercation with. And so bags were present on his hands. They were removed by me, and I did, in fact, obtain fingernail clippings from Mr. Bonnett. There was a scar, a 3-inch hyperpigmented linear scar in the lower midline of his abdomen. He did also have what we call our senile ecchymoses that had minor superficial skin lacerations. These are kind of what people call old age bruises.
Anything on the external, any evidence of fatal injury on the external examination?
Yes, absolutely.
And what, if anything, did you observe?
So moving on to the evidence of injury section on the report, initially the first thing that we described was a stab wound of his left upper arm. And the report has some specific measurements, and it has measurements of the actual wound. It has some measurements that kind of orient it on the body, and how, whether or not it has 2 sharp edges or just one. In this case, it had a single sharp edge at 9 o'clock. This helps us, it helps to indicate whether or not we have a single-edged weapon or potentially a weapon that has a serrated edge on the opposing side. And then it was described as having only gone down into the muscle and soft tissue about 2 inches. He also had another stab wound of his left upper arm.
You said that was in the upper arm, is that right?
That is correct. Left upper arm.
Left upper arm?
Yes.
Front, back, or side?
Specifically, that wound is 11.5 inches from the top of the head and 8 inches left of the midline. And so it is in the lateral aspect of that arm.
And would that wound have been fatal?
No, it would not.
And from the, I guess from the cut that was made on the body, I guess when inflicting that wound, can you give us any information on the knife that potentially was used based on that wound?
Well, again, as I stated a moment ago, it had a sharp edge that was at the 9 o'clock margin of the wound. And so that is indicative of a weapon that is not double-edged. Now, it doesn't mean that the weapon can't have a side that is serrated, but it does indicate that it is unlikely that it is a double-edged knife.
And that's for, as far as that wound, correct?
That is correct.
Okay. Now, there were other wounds, is that fair to say?
Absolutely. There was another stab wound within the left upper arm. It is also to the relative lateral, the outside aspect of the arm. It was T-shaped. It's a 4.3 by 1.5 centimeter stab wound. It was 14 inches from the top of the head and 11.5 inches left of the midline. That stab wound went down about 3 3/4 inches into the muscle and soft tissue of the left upper arm. So that's a decent distance. You think about that, 3 3/4 inches is right about there.
And again, that's in the upper left arm, near the other wound?
Near, yes.
Okay, and that was in the arm. Would that would have been fatal?
No.
Okay, let's go on to the next one.
The next wound is a stab wound of the mid-back. This wound specifically is a 3.2 by 0.5 centimeter stab wound. It is 18.5 inches from the top of the head and 1 inch left of the midline. And again, it is in the left side of the mid-back. It's oriented from 9 o'clock to 3 o'clock and reapproximates to 3.3 centimeters. These are just things we use when we describe the wounds. The path of the wound extends down into the posterior aspect, the back of the left side of the chest at the 10th and 11th ribs. It then goes into the thoracic cavity, and it goes through the left side of the diaphragm. It does not injure any other major structures. There is a liter of liquid and clotted blood that's collected within the abdominal cavity that is associated with that wound. That wound specifically has a directionality that is from left to right, front to back, and downwards.
And that was, you said that was the first wound in the mid-back, is that right?
That is correct.
All right. And would that wound have been potentially fatal?
It could have been fatal if, in fact, no care was rendered. It did not injure any large major structures, but by going into the back and going through the diaphragm, it absolutely would have caused a pneumothorax, and no medical attention would have meant that he would have passed away.
Now, let's one minute. Was there another wound in the back as well?
Absolutely. There are two combined wounds in the mid-back, and they are described exactly as that, two stab wounds in the mid-back that form a general L shape. And the first is given some description, same as these other wounds that we talked about, the measurements of it, 3.5 by 0.6 centimeter stab wound that is 14.5 inches from the top of the head and 2 1/4 inches left of the midline. In the left side of the mid-back, it's oriented from 7 o'clock to 1 o'clock and reapproximates to 3.7 centimeters. The second wound that connects with this, making that L shape, is 2.8 by 0.5 centimeters. It's 15 inches from the top of the head and 2.5 inches left of the midline in the mid-back. It's oriented from 9 o'clock to 3:30 and reapproximates to 2.8 centimeters. So then in the report, what I did with this, because these wounds do what we call commingle, they combine, I described it as such. I said, please note that due to commingling of the wound tracks of these two stab wounds, they are described together. The path of the wound extends down. It enters the posterior aspect, the back of the left side of the thoracic cavity, the chest, at the 7th and 8th intercostal space. The wound tract, the injuries, injures the descending aorta at the level of the 9th thoracic vertebra, and the left lower lung lobe is also perforated. Associated with that wound is a liter of liquid and clotted blood in the left side of the thoracic cavity. And the path of that wound is from back to front, left to right, and downwards.
Now, you did say you photographed during the autopsy, is that correct?
I did.
All right. Judge, have you already shown defense counsel is marked as Quebec composite, 4 photos in it? May I approach the witness?
Yes.
Judge, can I take a look at those 4 photos and tell me if you recognize them?
So far, yes. Let me look at the rest. Yes, I do recognize them.
Okay, and are those photographs consistent with the person that you performed the autopsy on?
Yes.
And some of them are actually from the autopsy, is that accurate?
Yes, all but one are from the actual autopsy.
Judge, at this time, I seek to move into Quebec.
Any objection?
No, Your Honor.
All right, state's exhibit Q for identification is now admitted into evidence is number 16. That's a composite exhibit. A through D.
All right, Dr. Stegmaier, so now that it's in evidence as state 16, composite, judge, may I publish to the jury?
Yes.
First, I'm going to show the jury the first photo, and that's Dr. Stegmaier, what are they seeing here?
This is a photo that law enforcement frequently sends us. We ask for something for an identifying image of the decedent when they first call us. If they have a driver's license, they send us a driver's license. If not, they will send us a copy of their screen, the computer screen. We always call it a David photo.
So does this help you in the identification process?
It does. It helps them in the identification process.
Now, let's talk about the wounds that you just testified to. I'm going to show them this one next, Dr. Steckler, just so you understand. And then if you could just tell the jury what they're going to see in this photograph, or these two photographs.
So what you're seeing in these two photographs is you're seeing one of our standard photographs of the lower half of the back of the decedent. But you're also seeing one of our other standard photographs of the upper half of the back of the decedent. And in that upper half, you can see that there are two injuries of the back. You don't see them as well because this is a general overall photo. Those photos are taken much closer as well.
Does the picture of the back kind of elucidate where those stab wounds were that you were testifying to?
It does.
And the one looks almost like a V or something. Is that the one we talked about having combined?
Yes,
A combination of two stab wounds?
absolutely.
So, and then there's another one down here, is that right?
Correct.
All right, so let's talk about this one here. This is going to be D in the composite,
Yes.
okay? If you want to narrate it while I show the jury.
Sure. So this is exactly what I was talking about. We did, in fact, do a close-up photo of those injuries with what is called an L ruler. It's a legal ruler. But there is also another photo there. This is as the tissue has been reflected away. That photo is actually of the injury from one of the stab wounds of the arm. It's showing that it goes into the deltoid muscle.
That's this one over here.
Yes, that is correct.
So one's a real up close and personal look at the arm injury, and the other one is a closer look on the two back stabs.
Correct.
Am I saying that accurately?
Yes.
All right, and then we got one more. Dr. Steckler, were you ever provided with a weapon in this case to examine?
I was.
Here's what the jury's going to see in this one.
So these
And I'm sorry, this for the record, this is 16B.
These photographs, the top one is actually just a standard image we take. It is what we call a face shot. These are often used for identification by family members and others because they can be cleaned up on a computer surface. The bottom one is a picture of the knife that was presented to us at autopsy as potentially being the weapon that was used.
And what was the purpose in presenting you with the knife?
The primary reason that they presented me with the knife is that there is a laceration, abrasion, impression along the nose that is quite consistent with the butt of that knife. They wanted to compare those two. We do, in fact, have an autopsy photograph where that knife is held adjacent to the decedent's nose, comparing the back of that knife to the impression along his nose.
Were you able to opine at all whether that knife would be consistent with the stab wounds that you discovered on Mr. Bonnett?
Yes, it is.
It is consistent.
It is.
Okay, and can you give the jury, like, how do you go about that examination of the knife to the wounds?
Whenever you're professionally trying to evaluate and say, could this be consistent with or not, you're looking at things like what we talked about earlier. Is the wound single-edged? Is it double-edged? Is the weapon single-edged? Is it double-edged? Things like this. If we have injuries that could have been caused by another part of the weapon, are there patterns to those injuries that would go along with some part of that weapon? In this case, of course, we do. And so when you evaluate those things together, it makes the instrument, the weapon, consistent with the injuries that you're seeing.
Dr. Steckler, I'm going to show you what's in evidence now. It states 14, and have you take a look. Do you recognize it?
Yes, it is the knife that was presented to me at the autopsy.
All right, and take a look at the blade of the knife. Is it that two different sides, or is it all consistent?
It does, in fact, have two different sides. One has a normal sharp edge, and the other has what we call a serrated edge.
Now, the stab wounds in the back, is it consistent, are those injuries consistent with having been caused by this knife?
Yes,
And what about the ones in the arm?
yes.
And then you said the butt of the knife also caused a nose injury?
It is consistent with the injury on the nose.
Okay. Can I have that perfect picture? One or two. Dr. Steph, I'm going to show you what's already in evidence in stage 6. You recognize the photo?
I do.
Is that Mr. Bonnett?
It is.
Now you see a nose injury there, right?
Yes,
Is that the nose injury you're talking about?
it is.
And you said it's consistent with having been caused by the butt of the knife?
It is. This photograph does not depict the pattern well. There is another photograph that depicts it much better.
Did you do a thank you, ladies. Did you do a toxicology on this person?
Yes, we did.
And when I say a toxicology, what exactly am I talking about?
It means that we did, in fact, obtain the specimens that we spoke about earlier. We did, in fact, obtain blood from the iliac vessel. We did obtain urine, bile, and vitreous fluid, and we did send those off to the University of Florida Toxicology Lab in Gainesville for testing.
And did you receive those results?
We did.
And what, if anything, did that test reveal as far as what was in Mr. Bonnett's system?
So the test revealed that his blood was, in fact, positive for ethanol, alcohol, at 140 milligrams per deciliter, or 0.14 grams per deciliter. And they do that conversion because it helps people to understand it. When you say 0.14, you can compare that to your reference range of 0.08 being the legal limit for driving while intoxicated. And so it kind of gives you just a general reference, and that's why they do that. The blood was also positive for cocaine at 301 nanograms per milliliter. This is important because cocaine is one of the fastest metabolizing drugs in humans. Almost all parent cocaine will have been metabolized to its metabolites within about 15 to 25 minutes. So having parent cocaine is significant in that it means that that cocaine would usually have been taken within the last 15 to 25 minutes. Otherwise, we would only have metabolite. We also have coca-ethylene, which was positive at 421 nanograms per milliliter. This is important because it lets you know that there has been some metabolism time between the alcohol and the cocaine. Those two combine together and create the metabolite coca-ethylene. Benzolecagnin was also positive in the blood. That is the primary metabolite, active metabolite of cocaine. It was present at a level of 1,958 nanograms per milliliter. And then when we look at...
Hold on, let me ask you a quick follow-up question. On the cocaine, were you able to, by the levels of these various breakdowns, I'm not going to try to pronounce them, but are you able to tell how recently he had used cocaine prior to his stabbing?
Right. So just to correct myself, it's 1,968 grams. Should have used my glasses, clearly. Just want to make sure I said not 1,958, it's 68. And yes, as I was describing earlier, we can say that at least the cocaine itself was used within roughly 15 to 25 minutes of his death, because again, we had parent cocaine in the blood.
And that's indicative from the coca-ethylene?
From the cocaine itself, because
from
again,
the cocaine itself.
Cocaine metabolizes relatively quickly, and so if you have parent cocaine in the blood, that means that cocaine was ingested or used within the last 15 to 25 minutes. The metabolites could in fact be due to the ingestion or use of the cocaine that we're seeing that's still in the blood, or they could be metabolites that are partially due to prior use as well. I cannot say that.
So the parent cocaine, the fact that it's in the system, would give you that time estimate of the last 15 to 20 minutes because it metabolizes rather quickly.
Correct.
All right, let's go on to the presence of any cannabinoids.
Okay, so
I was going to offer you my glasses.
Yeah, might as well.
See that?
There are cannabinoids present in the urine as well. They're positive. It is important to understand that urine indicates past use. Urine does not indicate current use. Blood indicates current use. And there were no cannabinoids identified within the blood. They were only identified within the urine, which again means past use.
Past use not present at the time when he was stabbed.
Correct.
All right, so then, anything else of evidentiary value from the toxicology report?
Well, it just depends on the questions that would be asked. The urine was also positive for ethanol at 185 milligrams per deciliter, and the vitreous humor, the fluid from the eyes, was positive at 140 milligrams per deciliter. Now, it is important to, oftentimes we look at blood versus vitreous fluid for different drug levels to say whether they're still in the absorptive phase or metabolic phase. In this case, they're equal. Both were 140, so that means that he's kind of at a steady state.
Of alcohol consumption.
Of alcohol, correct. And the urine was also positive for those other metabolites in active parent cocaine that we talked about, the cocaethylene and the benzoyl-9.
Now, you had said, so in all, he had cocaine and alcohol in his system. Is that fair to say?
In their metabolites, correct.
And you had mentioned his hands had been bagged, right, for preservation?
Correct.
Did you submit fingernail clippings?
I did, in fact, turn them over to law enforcement.
Okay.
Law enforcement then submits those fingernail clippings.
Did you provide them to law enforcement for further testing?
I did.
And did you also provide a DNA card for Mr. Bonnett for further testing?
I did.
Now, Dr. Steckbauer, when all is said and done, did you make any findings to a degree of medical certainty as to the cause of death here?
Yes, in this case, the cause of death was stated as multiple sharp force injuries and the manner of death as homicide.
Now, how are you able to determine it was multiple sharp force injuries and not cocaine overdose?
Well, again, the one injury, well, the two combined injuries that we spoke about.
The one that formed the V in the back?
Right. They, in fact, did injure the aorta, and they, in fact, did cause a good amount of blood to collect within the thoracic cavity. That is not compatible with life. It also had the injury that went through the diaphragm and up into the thoracic cavity and the blood within the abdomen. Those are not compatible with life. Although any amount of cocaine can cause a person's death, clearly the sharp force injuries were much more, I don't want to say impressive,
Dominant?
they would have a much greater effect.
So the fact that the stab wound in the back punctured or perforated the aorta, is that a fairly significant wound?
Yes, the aorta is the largest blood vessel in the body. It's under high pressure, which is why that blood collects within those cavities. The blood that would have been lost is, of course, probably even greater than that which we quantitated, because blood is going to have come out of those wounds. On top of that, you had emergency personnel who, in fact, were trying to save his life. They did a thoracotomy procedure in which they did open the chest in a way that we call a clamshell, which literally means they make a large incision, they open it up. They're trying to get access to repair those injuries emergently so that they can stabilize the person. And so some of the blood would have been lost then as well. So it's almost a certainty that he had lost more blood than what we're talking about in the report.
Now, did you issue a death certificate in Matthew Bonnett's name in this case?
I did.
And on the death certificate, you put in the information about cause and manner of death?
I did.
Was there, Dr. Steckbauer, I'm curious, was there any evidence on his body, Mr. Bonnett's body, of a struggle? Was there bruising on his arms or legs or knuckles, anything that would be evidence consistent with a struggle?
Well, he does have some additional injuries, and depending on how you would categorize those injuries, some of them could be indicative of a struggle. He had some bruising of the knees, if I remember correctly. For some reason. Oh, that's why. So specifically, he had a laceration. It was surrounding purple bruising of the bridge of the nose. We talked about that. He had a red abrasion, linear red abrasion of the bridge of the nose. He had an abrasion of the right cheek. He did have a healing wound of the right knee. Now, that's not indicative of an altercation at the current time because, of course, it's healing. But he did, in fact, have a purple-brown bruise of the right knee, which could be indicative of an altercation. He also had a brown bruise in the right foot, which could have been part of this altercation. He had a healing wound of the left knee. Again, it's healing, so it's old. He had a red abrasion of the left side of the upper aspect of the chest, which could have been a part of this altercation. He did also have a superficial red abrasion of the left upper extremity. Again, could have been a part of this altercation. And he had a laceration in the left upper extremity, which could have been a part of this altercation.
So many of those would be consistent with some kind of a struggle or a fight at the time of his stabbing.
Yes.
Judge, if I just may have 1 second.
Yes.
Judge, at this time, I have nothing further for Dr. Steckmeyer. Sir, thank you for your time today.
Right. We're going to take a little break before we have cross-examination. We've been in session here for a couple hours, so bear with us. It's going to be a 15-minute break. Members of the jury, you don't have to stay in the jury room. It's follow the usual procedures. 3:21, that would put us to 3:36. So see you back here. Continue the testimony. All right, our jurors have exited the courtroom. You can take a break also, Doctor. Just remember, we have the rule of sequestration of witnesses, so you're not to discuss your testimony with anyone during the break. Any other instructions? No? All right, we'll be back.